Hello, this video will help you better understand the situation you and your child are in. Your child is in detention, which is jail for persons 17 and younger. The reason your child is in detention is because there are legal charges against him that claim that he's broken the law. The purpose of today's detention hearing is not to decide whether your child is guilty or not of those charges. That'll be decided at another hearing on another day. At this first meeting with the judge, the only question that the judge will decide is, should your child be returned to your care and custody while he waits for the court date on those charges, or should he be kept in jail? The judge will consider 3 risk factors in deciding whether to release your child from detention today. The first risk is whether your child represents a danger to himself. For example, making cuts on his body, use of drugs, running with gangs, or suicidal tendencies. The second risk is whether your child presents a danger to the community. For example, his criminal record, if any, may reveal that he has harmed people or property in the past. Or will he be likely to commit further crimes if released? The third and final risk is whether your child is likely to run away before the court date on the charges. If you and your child cannot keep these 3 risks at an acceptable level, the law says that your child will remain in jail until those risks are reduced. If you and your child can keep the 3 risks at an acceptable level, then the law says that your child should wait for his court date at home with his parents. At this hearing, the judge will first listen to the probation officer. The probation officer will make a recommendation to the judge as to whether your child should be kept in detention. The recommendation could be that your child should be allowed to leave today, but under strict rules such as house arrest or placement in a diversionary program. The recommendation might be that your child remains in detention while the probation officer learns more about the charges. If so, the judge might authorize a prior release, which means that once the probation officer finds out what he needs to know and is assured that the 3 risk factors are reduced, he has the judge's authority to release your child from detention. You might be wondering what your role is today as a parent or legal guardian. The judge will turn to you after the probation officer has made his recommendation. The judge wants to know whether you want your child released from detention today. It may be that you would like your child to go home with you today, but want there to be restrictions. Maybe he can't contact friends, or that he be ordered to go to school every day and on time. Maybe you want to place your child in a treatment program so that he can learn how to respect you and better follow the rules at home. The probation officer, along with other officials, can help you with these arrangements. These hearings tend to last no more than 2 minutes and will be over before you know it. When the judge turns to you, he will not be able to get an accurate view of your child unless you speak up. The judge will make the best decision for your child only if you help him get a better handle on the 3 risk factors. Is your child a risk to himself, to others? Will he show up to his court date? Finally, you and your child have the legal right to be represented by an attorney at this hearing and any other hearings. An attorney can offer you the legal counsel and advice and can work out the agreement on the legal charges. There is information on how to get an attorney, maybe even for no cost, so please ask the officials about this information. Thank you.